Madam Chair, members of the committee, my name is Leili Fatehi and I represent Friends of the Mississippi River, a leading citizen-based organization that works to protect and enhance the Mississippi River and its watershed in the Twin Cities area. In the past year, more than 6,000 people participated in Friends of the Mississippi River's educational stewardship and monitoring offerings, working towards our common goal of a clean, healthy Mississippi River watershed. I'm also an attorney and have taught broadly on administrative law in the areas of science and the environment at the University of Minnesota Law School. Thank you for the opportunity to speak today against Senate File 695, which fundamentally and substantially expands the scope and reach of judicial review of the MPCA's actions by requiring an expensive, time-consuming, and unnecessary do-over of rulemaking whenever a regulated entity challenges one of the MPCA's decisions. Senate File 695 furthermore places responsibility for the do-over round of rulemaking in the hands of administrative law judges and the judges of the Minnesota Court of Appeals, giving them responsibility for deciding independently what scientific issues and data are needed to uphold or invalidate a rule. And in doing so, Senate File 695 not only requires judges with no subject matter expertise to engage in highly technical scientific analysis, but it also improperly delegates the power of rulemaking to the judicial branch of government. Rather than upholding or rejecting an agency's decision based on its consistency with the requirements and intent of the legislature, Senate File 695 requires that an ALJ or the Court of Appeals judges make their own independent determination of how those decisions should be made. Judicial review of agency actions is a critical tool of administrative law that exists for the purposes of ensuring that there's transparency and political accountability of agencies to the public and to the legislature. This is based on a 130-year-long recognition that agency rulemaking is a statutory delegation of legislative authority. And for more than 70 years, courts have upheld this principle by rejecting agency decisions only when they are unconstitutional, in excess of the agency's statutory grant of authority as intended by the legislature, or when arbitrary or capricious. Stated otherwise, for more than 70 years, it has been acknowledged that the role of the court is to decide matters of law and not substantive matters over which the legislature has acted to delegate rulemaking authority to an agency. This is so-called agency deference, and it means not only deference to an agency's technical expertise in a given topic, in this case the MPCA's scientific expertise on water quality, but it also means deference to an agency's political accountability as the body with a delegated legislative authority to make rules that have the force of law. Without agency deference, the court would be free to supplant its own judgment for that of the agency and, in essence, rule-make from the bench. And indeed, I did a pretty deep review of the legal literature on this matter, and it is clearly evident that even those who most strongly argue against agency deference limit the scope of their objections to deference on questions of law. For example, deference to an agency's interpretation of statutory language. Not even the staunchest opponents of agency deference would say that there shouldn't be any deference to an agency's evaluation of scientific data, as this bill calls for. Under Senate File 695, ALJs and Court of Appeal judges would be doing the delegated work of the MPCA, not only in terms of orchestrating a duplicate expert scientific review, but more importantly in terms of making an independent decision based on that review. This is the job of the MPCA commissioner, and it's a process that is required under the APA that includes notice and comment, opportunity for public input, and requirements for judicial review should somebody think that the agency either didn't do things correctly or have some other objection. Rulemaking from the bench, however, would happen without any requirements or procedures for public notice and comment in violation of principles of due process, and would be subject to review by a higher court, which seems to be uncharted territory. I'm not sure how the state Supreme Court, for example, would review a substantive rule that's been promulgated by the Court of Appeals. There are other ways in which the bill also erodes transparency and accountability of rulemaking. Under the State Administrative Procedures Act, ALJs and courts have to limit the scope of their review to the administrative record that documents the process and basis by which an agency reaches its decisions. And the purpose of this rule is to limit judicial activism. The court needs to only determine whether the record demonstrates that the agency's decision was made in accordance with the procedures that are required by statute, that it was supported by substantial evidence, and that it wasn't arbitrary and capricious. And as such, agencies are required to keep very complete and detailed administrative records, which serve as an important tool for public transparency and accountability as well. This bill eliminates the need for that record rules. It requires that ALJs and courts make a determination that's based in no part on the administrative record. And this is not only a functional requirement that there be judicial activism, but it also removes any incentive or reason for the agency to maintain a complete administrative record to the detriment of its transparency and accountability to both the public and to the legislature. Senate File 695 also creates a huge expansion of the regulatory system and process, adding considerably to the costs and delays of environmental regulations. Not only does it add an entire branch of government to the rulemaking and regulatory apparatus, it delimits the number of times a scientific review has to be repeated. Keep in mind that the bill doesn't say that the court gets to redo the agency's scientific evaluation just once. It says that they have to redo it each and every time an aggrieved party brings a challenge or can produce an expert that disagrees with the MPCA's approach. Furthermore, line 4.5 of the bill requires that the court ALJ assess the cost of the expert panel against the parties, except that local governments are exempt from paying these costs. As such, it creates an unfunded mandate for the state government, and all Minnesotan taxpayers end up having to pay the cost for the do-over expert panel, regardless of whether they live or work in the locality that's party to the challenge. This means that the cost of the do-over scientific review favoring a single petitioner would be often footed by Minnesotan taxpayers who already paid once for the original scientific review. And then finally, as a related matter, I'd like to point out that this bill is intended to benefit the specific agenda of a very particular interested party. The Coalition of Greater Minnesota Cities has brought a lengthy string of as-yet unsuccessful legal challenges against the MPCA's river eutrophication standards to limit phosphorus in wastewater that's been shown to be legitimate by virtue of the consistency of the court's decisions. Now CGMC seeks to fundamentally change the whole of administrative jurisprudence to avoid having to comply with the state's water quality standards. It's offensive that the proponents of deregulation push legislation to slam the courthouse doors shut when judicial review can serve to benefit the interests of the public, and then rally for legislation that blows those same doors open when they need judges to bend the laws for them. Minnesota simply cannot have one set of rules for the public and another set of rules for polluters, and I urge you to reject this bill. Thank you.
Thank you.